To my client, the reason why your project was subjected to both the Environmental Protection Biodiversity Conservation Act, EPBCA, and the Queensland environmental legislation, even though the project was solely based in Queensland, is because under Section 109 of the Australian Constitution, the Commonwealth law will prevail if it conflicts with state legislation. Under Section 51 of the Constitution, the Commonwealth has the power to legislate. However, the Commonwealth cannot legislate outside the scope of the authority invested in it by the Constitution. The Commonwealth environmental legislation often relies on heads of power like the EPBCA in regards to a trade or commerce power. And this can be found under Section 51I of the Constitution. Additionally, the project's actions will have a significant impact on national environmental significance regarding provisions under the EPBCA. While reviewing your documentation, it's stated that the project will have significant impacts on matters such as, for example, migratory animals. And migratory animals can be found under the EPBCA under Chapter 2, Subdivision D. Additionally, any project that is considered a controlled action under the EPBCA will have the potential to attract both state and federal environmental assessment requirements. And because of the significant impacts, you will need to apply for approval to proceed under the EPBCA, as well as any state or local government approvals that would be required. And finally, the Commonwealth will often be discrete in certain areas of the activity rather than taking over the whole activity. Thus, this will leave your project in good harmony between the Commonwealth and state laws.